Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV23-0329. I apologize if I've mispronounced names. Bassal versus Khalil. That's my best shot. So we are recording and live streaming the argument, so please identify yourselves and your client at the beginning of your arguments. Each side will have 20 minutes, but you're not obligated to use all that time. Appellant's counsel, if you watch the clock, and reserve as much time as you'd like for rebuttal. Also, please keep in mind we've read the briefs, we have studied the record, and we have discussed the case at our conference. Counsel for appellant, you may proceed.
May it please the court. My name is Peter Swan, and together with my co-counsel Kathy Sandweiss, I represent appellant Omar Bassal, who is here in the courtroom today with his sister. Your Honors, there are two major errors in this case, as I see it, that require remand. First, the trial court tried to apply cases about post-marital labor to the MASIC plan, but this case is about the distinction between premarital labor and intramarital labor, and that led to a clear legal error. I think the problem may be that when we see deferred compensation, we tend to think of it as a unitary concept, and when all you have is a hammer, everything looks like a nail, so people tend to apply deferred compensation cases without regard to the types of facts of the case that they're dealing with. If we ignore the premarital and the postmarital distinction, error results. Second, the court found that equal division in this case was appropriate, expressly found that, and then failed to divide the marital property even close to equally. Both errors require remand. Let's begin with an undisputed fact. If Mr. Bassal had not worked at MASIC in 2014, in 2015, in 2016, and in 2017, he would never have received awards for those years. There can't be any argument about that. And during those years, he was unmarried. There can't be any argument about that. This court's recent decision, as Judge Thumma wrote in Stock v. Stock, the fruits of labor expended before marriage are separate property. It's as simple as that. The rule in Stock expressly applies regardless of whether a deferred compensation system has vested or not. So nothing more complicated than Stock was necessary to decide the separate versus community character of the MASIC awards. And the case needs to be remanded for a proper calculation. The calculation is actually quite simple. It's 80% is separate property minus 7 days for 2017.
1 year and 1 week is what you're saying.
I'm sorry?
1 year and 1 week of a 5-year period. Is that
yes,
correct?
And we readily concede that the portion of the award earned during marriage was community. There's no argument about that. But the portion earned before marriage cannot be community. And I think that the court kind of tied itself up in knots with Hugg and Nelson trying to deal with vesting issues, but those issues become important when the vesting happens after the marriage, and we're worried about the labor after the marriage that would go to benefit the community retroactively. Neither Hugg nor Nelson says one word about premarital efforts. Stock does. And it surprises me a little bit that it took until 2021 for a case to come before this court and result in an opinion that made that clear. But it did.
Can we move to the second issue?
Sure.
Let's move to the second
the second error, the
Yes.
equal division error?
Yeah.
Sure. So this relates largely, but not entirely, to the trust, the charitable lead annuity trust, which we call the CLAT. few things about the trust that I don't think can be disputed. Number one, by its terms, the marital community is not a beneficiary, doesn't have a beneficial interest in the trust.
Your client is a sole beneficiary, correct?
No, the marital community, it was formed during the marriage. Our position is that the marital community is a residual beneficiary. If the trust terminates according to its terms at the end of its period and there are assets left, then the community has a residual interest. But right now, neither my client nor Ms. Benson's client is a beneficiary of the trust. That's why the trust gets such favorable tax treatment. Otherwise, everybody would stick their money in there and be able to take it out when they wanted and not pay taxes on it. But the federal tax law gives significant benefits to the creation of these trusts because it is a true alienation of the property. These parties don't have an interest in the corpus of that trust until it terminates, and maybe, just maybe, there is a residual interest. We have no problem with the concept that the community should share equally in any residual benefits.
Is it accurate to say that your client could use the trust assets as collateral to borrow against the trust? Is that accurate?
Well, the terms of the trust have that sort of boilerplate language, but because he has no rights to access them and the trust itself can't be invaded, it's not a practical right. I mean, you can say in a document you can borrow against this, but it's not meaningful collateral because it's not my clients, it's not the marital communities, it is alienated. Well, go ahead.
I was going to say, I wanted to walk through this a little bit to make sure I understood. Because we're reviewing this portion for an abuse of discretion. Is that correct, not de novo?
Actually, Your Honor, I think there is a de novo component to this because you have to ask yourself whether 25318 was properly interpreted and applied. And here, I think the terms of the decree itself makes clear that it was not. And that's a de novo review of the decree. The decree says, after analyzing law concerning abnormal expenditures and waste, it then says, in this case, there are no extraordinary circumstances and equal division is what is required to achieve equity. That's what the court said. Then, when it dealt with the trust, it had Mr. Bassal responsible somehow for going out and making a couple $1 million to pay for it, but it never awarded him the trust. It never awarded wife the trust. Mr. Bassal has an obligation with no corresponding benefit, and that itself is the very opposite of equal division. That requires remand because the court violated its own decree.
Is Mr. Bassal the manager of the trust?
The manager of the trust, I believe, is an entity that is Mr. Bassal's sole property, if I'm not mistaken. And I'd be happy to supplement the record on that. But Mr. Bassal does not have the discretion, and federal law is really tight on this. Creating one of these trusts and avoiding all the tax on the money that you contribute is not an easy ask of the federal government, as it shouldn't be. Mr. Bassal already paid over $2 million in taxes on the Massac payout, but took some of the money and put it into a charitable trust that was tax-free. It is not surprising that federal tax law requires such a trust to be set up in a way where you don't have access to that money. Otherwise, it's just creating your own tax-free account, which the law doesn't allow.
Is it fair to say the Superior Court didn't direct your client to invade the trust assets to pay off?
No, and that's part of the problem, and that's another part of the de novo component of the review. If anybody's sensitive about the idea of deferring to trial court findings, it's me, but the trial court didn't make the finding that the court needs to evaluate the rectitude of the decree. The trial court said, this trust is likely irrevocable. It didn't make a finding as to whether it was irrevocable. It didn't make a finding that the funds...
I think the record's pretty clear that it is irrevocable.
Well, I would agree, but I don't think it's possible for this court to make that finding. It's tempting, but I think that's something that has to be done on remand. because the entire record of the trust, there may be expert testimony, all sorts of things on remand that go into making that finding that the court apparently felt unable to make. So
let me walk through this, because I'm trying to think of what other scenario might be analogous here to this trust. And I'm trying to think. Let's say your client and his former wife they held a closely held business. It was a farm, and all of the marital assets went into capital to improving the farm and getting that up and going. And then there's a divorce, and there's an order. It seems to me that it's not uncommon for a court to say, okay, husband, you don't want to sell the farm, but I'm not going to let you wait till the farm is profitable before you buy out wife her interest. So take a loan out against the collateral on the farm. Am I off in left field?
Well, I don't think you're off in left field, but I think you need an additional fact to make the analogy work. If you invest all your capital in the farm and then you give Aunt Millie a life estate in the farm, she now owns the farm until she dies, and you, the donor, can't do anything with it until the expiration of that estate. And here, the expiration of that estate is the defined end term of the trust, when there may be some residual value that could be divided. But when you give it to Aunt Millie, you can no longer borrow against anything unless you can find somebody to take collateral in a residual instrument. And if Aunt Millie's only 30 years old, that's going to be a pretty hard loan to get. So when the interest of the community is purely residual, it is that residual interest that must be divided. And here the court didn't attempt to value the residual interest. In fact, it didn't even attempt to divide it by percentages. It didn't say 50-50 when the trust terminates, which would have been a perfectly legitimate order, subject to the internal calculations as to value, which are erroneous themselves because of the Massick miscalculation and also the refund of shares, which we haven't discussed, and I'd like to touch on very briefly if I could.
Go back.
Sure.
Just help me out. So the residual interest, are you saying it was not evaluated or was not divided, or both?
Both.
Neither.
The court didn't do either one.
Okay. But on top of that, did your client's expert present testimony or offer an opinion on what that residual interest should be?
Only that there was a theoretical residual interest which might have value and might not, and the court easily could have said, in fairness, I don't think the court could have assigned a precise value to residual interest years in the future. But what the court easily could have done, what courts do all the time in family court, is just say, when this interest ripens, it's split 50-50 between husband and wife. But remember, the court didn't even award husband the trust. He awarded wife her miscalculated value of the trust, but he didn't award husband the trust. So husband is buying the trust for wife and getting nothing in return, which is so far from equal division. It may be the polar opposite of equal division, to simply award all of the property to one side.
What did wife claim that the trust was community?
Well, wife claimed that the contributions to the trust were community, except for there was a tranche of shares contributed that wife conceded was husband's sole and separate. But then a good chunk of the money came from the Massick payout, which was wrongly allocated. And then the third component that requires discussion is the refund of performance fees in the form of 2018, it's an unfortunate number because it sounds like a year, but it's a quantity of shares that was given to the trust essentially as a refund for overbilling. The trust was paying fees that under the tax law governing the trust, it really shouldn't have been, and so it was made right. And the court treated that contribution as entirely community and awarded wife half of it. The analogy there, Your Honor, would be if I overbill my client by accident on a case and I refund some of the money, That's not a marital community benefit. That's between me and my client. We're just accounting for an overcharge. It's not that I just gave my client a community gift. So that really should have been a zero. That was simply a wash of an overcharge versus a refund. The shares contributed did not come from the marital community. They came from husband's separate business, and the court simply added that to the bill, while again awarding husband nothing to balance out the amount that he was giving up. So there was no division of the trust at all, and I submit that's such a fundamental error that on a de novo review, the court can conclude that a remand is required on that issue. Okay. One last point before I try to save a few minutes for rebuttal, and that is the notion of waste. I expect my colleague is going to argue that the court's assessment of my client created some pervasive finding of waste that justifies all this. But there are two reasons that fails. Number one, the terms of the decree itself say equal division is appropriate. The terms of the decree nowhere mention the word waste. Nowhere cite ARS 318C, which governs waste. And nowhere purports to make a finding of waste. In fact, says there are no extraordinary circumstances here that would require anything but equal division. The court then later on says some unflattering things about my client that might sound like waste, but I would point the court to, two members of this panel were actually on Meister v. Meister, in which this court held, Judge Brown, I believe you're the author, held that the pervasive, some implied pervasive finding of waste was insufficient to permit reasonable appellate review, and the case has to be remanded. If the court wants to find waste, it needs to make a specific finding that goes to a specific result. So any generalized sense that something might not have been according to Hoyle here is not a finding upon which a result can be based. So on the facts...
While we're on this subject, can you clarify what the court was referring to, or what you believe the court was referring to when it said, given the manner in which mother and minor child had to return to the United States?
That was interesting, wasn't it? And Your Honor, it's not in the record, but I can clarify it if you'd like, because there was, and stop me anytime you want.
Well, it's not in the record. It wasn't the subject of testimony?
It was a fracas during temporary orders that I don't believe is in the record on appeal. And what the court was addressing was a dispute about where wife returned after threatening to take the party's child to Pakistan, which understandably, since there's no extradition, troubled husband. He bought her a return ticket to Arizona. She wanted to come to California because she didn't want to be subject to jurisdiction in Arizona. I could go on, but we're well outside the record. And you know, impressions form at the trial court when you hear these things, and I understand that. In this case, the court had an erroneous impression, and I would be all over that finding, challenging it as clearly erroneous, if it had made a finding that contributed to the result. But here it's just this generalized atmosphere that the court injected, which Meister held was not an adequate finding to support the result. If there are no questions at this point, I'd like to save 2 minutes for rebuttal. Thank you.
Good morning, Your Honors. Melissa Benson on behalf of Appellee Kushbo Khalil. And before I get into my outline, I wanted to just address the last statement regarding what the court indicated on my client's unusual manner to come into the States. Mr. Khalil had taken the child's passport. They were in a Middle Eastern country where my client was not able to transport the child without her husband's consent. She had to go to the State Department, prove that domestic violence had occurred, to get passports reissued to her, and then carefully schedule buying the flights in cash, getting to the airport at a time when husband wouldn't know where she was to be able to get back to the States.
Is that information in our trial record?
It's in the temporary orders, Your Honor.
And are those before us?
No, Your Honor.
Okay.
But I just wanted to give the court
Sure,
some
I understand.
context.
Thank you.
Okay. There are primarily three questions before the court today. The first is the characterization of the MASIC stock and whether the court abused its discretion in its allocation of the MASIC stock and its calculation on how that stock was attributed.
Counsel, are you familiar with stock v. stock? I'm assuming you've read that before argument today.
Yes, Your Honor.
Do the principles in stock v. stock apply?
This case is distinguishable, Your Honor, because it is not stock. These are not stock options. They were not vested. And in Brennan v. Deanne, the court specifically indicated that the trial court is vested with broad discretion. And with the way that in Brennan v. Deanne, the court indicated that we should look to the employment agreement to determine exactly what these are.
But not broad discretion in determining whether property is community or separate. That's a matter of law,
Yes,
not
Your
a
Honor.
matter of discretion, correct?
Yes, Your Honor. But in calculating what is separate and what is community, the court has broad discretion in choosing which formula and what's the most appropriate. The problem with this particular MASIC, and we say stock because they're titled as virtual shares. However, they convey no ownership interest in the company. They do not vest until 5 years. And in fact, the employment agreement itself specifically states that while they are allocated during that time period, they are not owned until they vest after.
Doesn't the agreement state that once they are earned, they cannot be unearned, they cannot be taken back?
Actually, that does not what the agreement states, Your Honor. The MASIC stock plan has a whole section on forfeiture. And in that section, if you're an early leaver, if the company doesn't meet the 85% of the target refinance, then, and if you do not work for the company for 5 years total.
Sure. Let me read one portion of it, of the agreement. It says the allocation of virtual shares is subject to employee performance each year. As long as participating employees meet performance expectations in a given year, they are allocated 20% of their 5-year share award in full. Is that accurate?
That does, but Your Honor, if you go down to a separate page, it says, please note that allocation means that the shares have been set aside for the employee, but are not owned by or due them yet. So you still have to meet the other criteria in the stock plan in the virtual scheme.
They're earned but not vested. Is that what you're?
They're allocated, so they're set aside,
Right.
but all of the other criteria have to actually be met before any of them are actually earned, have any value whatsoever. And there's a whole forfeiture section. And then it goes on to talk about virtual shares vesting later in the same document. And it says the virtual shares generally vest after 5 years. And at which point they are then owned by and due to the eligible employee.
Are you talking about ownership, or is the right to own the shares? I don't know how to say this. The Potoff, how you say the case, you're familiar with it probably, Potoff case says, time of acquisition refers to the time at which the right to obtain title occurs, not to the time when legal title. So I don't know that, I mean, was husband arguing that he acquired legal title to these shares each year, or that he had the right to these shares?
Husband's argument, at least my understanding of husband's argument, Your Honor, is that he obtained the shares each year, which I would submit to you is incorrect. The shares don't actually have any value until all of the criteria are met, and the earliest that would happen was in 2019 at the shareholders meeting related to 2018 to see if the company met the goal. And that was, I believe, and I could be mistaken on the date, March 1st of 2019, which is well within the marriage, which is why wife's argument at trial was that this is 100% community. It vested during the marriage, and then it was received and owned during the marriage. It was cashed in during the marriage, and it was claimed on the parties' income taxes as income during the marriage.
So help me understand, how is this different than a stock option? So assuming you had the same almost exact wording, but it was stock options instead of a virtual shares.
Because the stock options give you an ownership interest in the company, and MASIC specifically says in its agreement that this gives no ownership interest.
Even if but what if his stock options had the same exact language about forfeiture? Then would your position be that there is no ownership interest until it vests?
My position would be the same, Your Honor, that there's no ownership interest because the way that this is phrased and worded throughout the employment agreement, and whenever there's a dispute as to what the employment agreement means, we look at the agreement and the plain language of the agreement is clear.
You said that it didn't vest until the marriage, but was the employee labor expended before the marriage?
Yes, Your Honor, which is why our alternative argument was that the court should use Nelson, because the agreement, the MASIC Employment Incentive Plan, what specifically states that it was to incentivize the employees. It actually says reward both short and long-term performance. And in certain cases, eligible employees could lose their virtual shares allocated to them prior to vesting. And so if you're not meeting your goals, it's an incentive for you to continue to remain with the company and meet the goals, especially because there's the 5-year requirement. If you do not work for the company for 5 years, you are not entitled to these unless you leave on a good leaver. And good leaver is very clearly defined, including death, disability. It's not you found another job. And so I would submit to the court that MASIC is not traditional stock, and there's no analogous case directly on point because of the creative way that they are construed. The second issue is also heavily fact-intensive, and that is the apportionment of the assets and debts, specifically the CLAT and the community waste. ARS 25-318C, nowhere in it mentions the word waste. So there's no requirement that the court specifically say you committed waste. This is merely a term of art. The court did make findings that husband funded the CLAT without any knowledge of wife. Husband spent over $1.3 million to his family members without wife's knowledge, consent, or agreement, and that husband virtually controlled the entire family finances without wife's agreement.
It was, do I remember correctly that husband primarily claimed that he paid that money as a thank you, appreciation to his parents for his upbringing? Is that correct? He didn't indicate he had a legal obligation to pay that. Is that
Yes,
accurate?
Your Honor, that it was a thank you. But husband also sent money, and the testimony from the expert showed that husband also sent a significant amount of money back to his previous employer, MASIC. He sent other significant amounts of money to family members for family support. He did capital injections into his company, Shoe Car Investments, and he funded the CLAT. So there were large amounts of money that he dispersed without any benefit to the community.
Are you aware of any case law that finds that gifts, payments to family members, it constitutes waste? I mean, any examples that you could find? Or?
Not off the top of my head, Your Honor, but I can prepare a supplemental brief if you would like.
That's okay. I just wondered. So thanks.
And the court, within its discretion, looked at all of the assets and all of the factors, all of the testimony, and utilized that to effectively order husband to make what's commonly called equalization payments. There's nothing that requires the court to dictate how husband pays those equalization payments because he has all of the interest in the CLAT. The CLAT is essentially a self-licking ice cream cone.
He has all interest. Did the court confirm that? Because opposing counsel says that the court didn't make any finding on that.
The court heard testimony, Your Honor, but I don't believe the court made specific findings. The court did indicate that husband has very nested interest in his finances, which isn't as clear as I would like for it to be for today. But essentially, husband formed the CLAT. Husband's company is the company that controls the CLAT. Husband is the remainder beneficiary of the CLAT. Husband formed the CLAT with only assets from his company. Husband was paying his company to administer the CLAT. And the charity that husband picked is a charity that utilizes husband's company.
But the CLAT, 2027 is the magic year for the CLAT to end. Is that correct?
Yes, Your Honor.
Why would the court not have, if there's no other significant asset for husband to make these equalization payments from, why is it not an abuse of discretion for the court to say, we're going to revisit this in 2027 and a percentage, whatever that is, goes to wife? Why did the court not do that, or should the court not have done that?
I would submit to you that the court should not have done that because essentially it leaves wife penniless, where the testimony throughout...
Penniless might be a little like an exaggeration.
With virtually no assets. She has one bank account that she was awarded that was her sole and separate property. The other bank accounts were in husband's custody and control. And as was outlined in our response brief, husband has made no payments toward those equalizations or this equalization payment from the wife. So wife now lives in Arizona with no support other than the spousal support, which is the issue number 3. I know it wasn't brought up by my client, but by opposing counsel, but if the court wants any information about that, I have that outlined as well. But back to the CLAT, the court indicated that...
So let me ask you this. Sorry.
Yes, Your Honor.
If the court had deferred the payments and said, in 2027 we'll revisit, could the court have done that? Would that have been error, or would that have been within the court's discretion?
I think that they're both within the court's discretion, Your Honor. And the court outlined why the court made the decision to make the payouts when it indicated that it's likely Ms. Khalil could have more money at the end of the beneficiary because husband is a very skilled financial investor. But the court was loath to leave that much power with Mr. Bassal and leaving Ms. Khalil at the essential mercy of his management of this CLAT. And throughout the marriage, Mr. Bassal had significantly large amounts of income coming in. He was a very skilled investor. The testimony at trial was that they spent a month at the Four Seasons in the Middle East. They flew first class everywhere. They went to France, Greece. Mr. Bassal himself testified that it was the highest level of lifestyle that one could have.
You're not suggesting that's waste?
No, Your Honor.
Okay.
I'm not suggesting that that's waste. I'm just suggesting that his arguments today that he would have to magically find this money out of somewhere is disingenuous.
Okay.
And the court isn't required to tell him where he attributes the money. As the language in the CLAT says, he can borrow against the CLAT. That's in the record. And he is the sole person who has access to all of the assets in the CLAT to make the payments to the beneficiary, to invest, to buy shares or sell shares, to help make that CLAT grow.
So the CLAT has specific language allowing him to borrow against the principal.
Yes, Your Honor, and it's cited in our reply brief. I believe it was, and I can give you the site if you'd like it.
That's all right, thank you.
Okay. And that dovetails into the spousal support argument, that the court somehow abused its discretion in awarding wife spousal support. We would submit that the court did not abuse its discretion and did not misinterpret the law. the court made very specific, detailed findings for all of the categories in awarding spousal support. I believe from my reading of all of the briefings, the biggest contention was the court finding that wife does not have sufficient property to support herself.
Yeah, what evidence supports that finding?
The evidence that supports that, Your Honor, is virtually everything that she was awarded is in husband's possession. And so at this point, until payments are made, they're merely a promise of a payment to be made. Until that's actually realized, she has no payments. She has an enforceable interest that has unfortunately been a little bit delayed. And you cannot support yourself on a mere promise. She was awarded her sole and separate bank account, which amounted to about $70,000. And the property from the Middle East were mere household items, such as rugs, coffee makers, that the parties divided once it arrived from the Middle East. To say that she needs to have a giant yard sale to be able to meet her reasonable needs just isn't in line with the law or the case law. And that would assume that we stop at that factor. The court made findings under other factors, and the statute only requires a finding under one of the factors to move on to the next, to determine that wife is entitled to an award of spousal maintenance. The court found not only that she lacked sufficient property, but that she had made significant financial contributions to husband's career. Shortly after the marriage, they moved to the Middle East. The testimony in the record was she wasn't allowed to finish her degree. She had some internship type things that she needed to finish to be able to finish her degree, to be able to work in her chosen field. The testimony at trial was husband refused to allow her to do that. The testimony at trial was also she worked briefly at the embassy. However, husband would not let her continue that job because it interfered with her wifely duties. And it was even further complicated because of the culture in the Middle East. Her employer wasn't allowed to speak directly to her. He had to call her husband to communicate things to her. And so the court allowed her time for rehabilitative spousal support, which is well within the court's discretion. And if the court doesn't have any questions, that's everything that I have.
Thank you.
Okay.
Give me a quick 2 minutes. I do take issue with having an argument called disingenuous. The court can take judicial notice of the fact that there's been no supersedious bond posted in this case, nor have there been enforcement actions because Mr. Bassal no longer has the money that he once did. Mr. Bassal is living on a shoestring also. The notion that you can borrow against the principal, sure, there's a legal document that says that, but the document also requires the trust to dissipate its assets. Not too many lenders are going to lend on a corpus that is supposed to, by its terms, be dissipated to nothing or near nothing. So I think the borrowing is something that is not practically on the table. As far as testimony about that may have led to a spousal maintenance award about wife's employment and everything, let me just put it to you this way. The testimony was not one-sided, and if you're inclined to consider Ms. Benson's comments, I suggest that you read the entire transcript. Ms. Benson said this isn't like stock because these are not stock options. Well, stock was not a stock option case, ironically. Stock was a federal pension benefits case, and in that case, the marital community actually spent community funds to buy back time to augment premarital service. And this court held, sure, that money you spent to buy back time is community, but the time remains separate. So I don't think we can say that stock is distinguishable. As far as vesting under the plan, let me just point out this. If you look at IR 99, Bates OBO 2034 and 2035, you will find inconsistent references in the plan itself to vesting. You will find that an early leaver, even somebody who leaves on bad terms at the discretion of the board, may be awarded quote unquote vested shares. Under other terms of the plan, the shares wouldn't have been vested, but under stock, vesting doesn't matter. So I think that's a detour that the court doesn't need to take. Lastly, I would just like to point to 25214C. This acquiescence concept in the order is irrelevant under 25214C because this case does not implicate any of the three statutory exceptions to joint management and control where each spouse has the power to dispose of assets. And I think I'm over time, so I appreciate your indulgence. Thank you, Your Honor.
Thank you. Counsel, we thank you both for your arguments. This matter is under advisement. The court will will issue a decision in due course, and the court is adjourned.